Disciplinary procedures often phase organisations. They can seem really complicated and quite frightening because they can end up in litigation. If you dismiss an employee for misconduct, it can result in a claim for unfair dismissal, and that often paralyses the staff who have been charged with executing such a procedure. In practice, disciplinary processes are not that complicated. They just need to be done methodically and consistently. But given that fear, we can help you run those procedures to make sure that you adhere to legislation, but at the same time run a process that is fair to your organisation's outcome as well as to that of your employee. Disciplinary procedures are needed when an employee carries out an act of misconduct. So that might be stealing from another colleague or stealing from the organisation. So it's what you do, it's kind of like the internal court of an organisation. It's how you make sure that people adhere to your rules. It's really important that people understand what the difference is between normal behaviour and misconduct. The best way of outlining that is by creating a disciplinary policy. What that will do is set out the rules for the organisation. So like I say, stealing is quite obviously in most spheres of life not acceptable, but there may be more subtle rules to do with the practice of the particular organisation involved. So you set out what you find acceptable and what you do not in that disciplinary procedure. You also then go on to set out how a process, once disciplinary action is being taken, how that flows forward. The really important thing to gain about disciplinary policies is that they meet your needs, that they are consistent, that they are not setting you to do things that you are too complicated. But obviously the downside is once you set them out, you must actually continue doing them and you must run with them all the time. Failure to do so can potentially involve a breach of contract, which could also elicit further litigation from your employees. When you're setting out your disciplinary policy or the rules within it, it's absolutely critical that you refer to the ACAS Code of Practice. This is the definitive document set out by government that tells an organisation how to run and what must be included in a disciplinary procedure. It does also cover grievance, but we're not particularly going to look at that in this session. But what's absolutely important is that you pay close attention when designing your policy to it. If for any reason you don't have a policy, you still must adhere to the Code of Practice as an absolute minimum when you are conducting disciplinary procedures. Another important factor that you most likely will not write down in your disciplinary policy is that the importance of natural justice. All you really need to know in terms of disciplinary procedures is that it governs fairness. So you must at all times be considering fairness when running a procedure. Is what you're doing to your employee by way of process fair on them? It's what actually dictates most of the law in this country. But in terms of a disciplinary procedure, it's people's right to be heard. So the rights of both parties to put forward a case, to have them considered, and that you are considering actual fairness, but on some occasions procedural fairness and the appearance of fairness as well. For example, if you've got an employee who was working with somebody that they knew really well, it wouldn't seem appropriate that the other person was heavily involved in the process because that would appear to be unfair. It may actually be unfair, but it's also about the appearance too. So at all times, do consider how fairness runs through your process, whether people have had the right to reply, and whether they have been treated appropriately right through the whole process. So we've talked about the need to write down your rules in a disciplinary procedure, but it's also quite useful if it's a procedural and process document as well. So there are some key parts that are dictated in the ACAS Code of Practice that you need to think about. Once an accusation of misconduct has come up, for example, some money's gone missing out of petty cash that cannot be accounted for, it's really important before taking any action to establish the facts. This has been taken care of many times in case law and is absolutely critical. It's so important that the cases from the 1970s still stand as current case law, so that indicates to us just how important it is. How do you establish the facts? You must carry out an investigation. Most ideally, you would get different people to do each different parts of the process. So it's not the same person coming in at the beginning and then making up their mind about what's happened. So establish the fact by investigating. The best thing to do is to get one person to look into the things, maybe interview witnesses, take statements. Then they will compile a report and they would then make a recommendation as to whether a hearing was required, whether there is any case to answer. Presuming that that is the case, that misconduct has been, that the facts look like misconduct has taken place, we're still nowhere near the point where a decision is being taken. The next step would be to invite the person accused of the misconduct to a disciplinary hearing. Now, an important part of the statute is that you do invite them by letter, make sure that the details of what they are being accused of are outlined in writing. Clearly, make the venue and time of the meeting quite clear, and also make the employee aware of their right to be represented by a trade union representative or a work colleague. Once the hearing is being held, it's a case of the organisation putting the allegation to the employee, stating what all the facts are. It may just be summarising the report that has been prepared, but it might be more of a discussion, and then allowing that employee the right to reply, the right to defend their position and put forward. It may be a case that they hold their hands up and say, yes, I did it. It was me. I admit that my guilt to that misconduct. But it might be more that they are presenting some sort of defence or mitigation to what's happened. Only after that meeting is complete and everybody has summarised what's gone on and all the facts have been heard, the meeting will close. Only after that point do you then make a decision. Anything that indicates that the outcome may have been prejudged through investigation or hearing could also be seen to be unfair, and if any sort of claim was made at an employment tribunal, it might be seen that it was procedurally unfair because the outcome had been prejudged before all the facts had been heard. Again, if you want to make an equation to a criminal court, it's like having not heard all the evidence properly before coming to a judgment. So you've had the hearing. The panel involved, it may be one, it may be three people, then make a decision. Do they find that the misconduct has taken place, or do they overturn the decision? That must be communicated in writing. So you would write to the employee with the outcome and any sanction and the reasons why that sanction had been applied. Any sanction that is applied, that any employee has the right to appeal against that. So whether it's a first warning, whether it's a final written warning, or whether it's a dismissal, they must have the right to appeal. And again, ideally, this appeal would be heard by a fresh party of people who have not been involved at any point up until then. If you follow out that simple process, then your disciplinary hearing should run fairly simply. However, there are plenty of pitfalls, and each set of circumstances throws up their own complications. So, as ever, we are on hand to support you right the way through these processes should you need to. So as you can see, a disciplinary procedure doesn't have to be particularly complicated. You've seen all the steps. As long as you follow your own policy, with reference to the ACAS Code of Practice, it doesn't have to be particularly difficult. Nevertheless, if this process still seems really difficult and you can't face doing it alone, whether it be conducting investigation, attending the hearing, or just having some advice in the background, our service can help you with that at any point. So please get in touch and we'll see how we can help you.